We'll get started. Just make sure your mics are on and cell phones silenced. Has everybody had a chance to look over the minutes from January 5th? Any questions on that? Comments? Does anybody want to make a motion for those?
Make a motion, we accept the minutes.
Frank, thank you.
I'll second.
Jenny?
Yeah.
Yep, thank you. All those in favor? Aye. Any opposed? Okay, so the minutes are good. If anybody's speaking tonight, can you make sure that you've signed in? And Charlie will get you sworn in right now if you're speaking.
If everyone signed in, if you could stand, please raise your right hand. Do you swear or affirm the statement you're to make tonight to be the truth to the best of your information and belief? Do. Thank you.
Okay, thank you. And did you already get the sheet signed that you needed?
No, we're still working on it.
They're still working on it? No,
Oh, the minutes?
Yeah.
Oh, no.
I think,
No, they're right here.
I think
They are right here.
I signed those.
In that case, I'll pass them your direction.
Okay, I'll do that real quick. Let me just make sure with him. Is it okay if I sign these based on the one recusal I had? Okay, just wanted to make sure.
Yep, you're still the chair.
Thank you. All right, one. And you want both of these back, right?
Yes, sir.
All right, that's all good. And we'll go ahead and get started here. No old applications, so we'll go ahead to the new, starting with A. Go right ahead. Thanks, guys.
Oh, God, this was such a... minutes.
First application on the agenda, conditional use permit at 550 Delaplane Road. File number is G 2026-04. The proposal is a conditional use permit for an outdoor storage facility, kind of adjacent to the use of the primary use of towing. The zone is I-1 light industrial. Surrounding zones are I-1 and A-1. Lot size is 5 acres. Direct access is from Delaplane Road. Arterial access is from Cherry Blossom Way, and staff does recommend approval on this application. Pictures of the site here. Pictures of the site from the zoning map. So some background. Portion of the site in question for the conditional use will be leased by the applicant from the owner of the site, Hatfield Hauler Incorporated. The applicant intends on leasing this section of the property for the storage of vehicles incidental to the primary use of a towing business or facility. Because the applicant will be expanding upon the current use of the property as a separate tenant, the business will require a separate conditional use permit. The applicant has confirmed the following details of the use. There will be no odors generated. There will be no more than 15 to 20 cars stored on site at one time, and that may come up later in relation to conditions of approval. The use will not be a junkyard. It will not entail the breaking down of vehicles for spare parts as defined by our ordinance. Vehicles will not remain on the site for more than 45 days, and that will come up in relation to conditions of approval. Had some new material from the applicant shortly before the meeting. The use will not create noise, glare, or disturbance for surrounding neighbors. And the applicant may further speak regarding the scale, nature, and the intent for the business. So the site, under current conditions, currently has multiple structures and stored vehicles pertaining to the current owner's use. The application would be consistent with the typical uses that we find in the general vicinity. Majority of properties are zoned I-1 or I-2. And TMMK, Toyota Motors, is less than 1,000 feet away from the property in question. So while the use abuts A1 parcels to the west and east, staff does posit that effective screening, fencing, and buffering would eliminate potential disturbance to the neighboring agricultural properties. Some of that is in existence, and some of that will be conditioned or required for this use. The western portion of the site is in the 1% annual chance FEMA floodplain. The applicant has stated that the portion of the site that they intend for this use will not be within the floodplain, and staff does recommend a condition of approval to ensure that this happens for the site. And you can see here a picture of the floodplain over to the west of the site, and the general area where the applicant will lease from the owner for this use. So KRS 100, statute for conditional use, KRS 111.6 defines conditional uses as those which are essential or would promote the public health, safety, or welfare in one or more zones, but which would impair the integrity and character of the zone in which it is located, unless restrictions on location, size, extent, and character of performance are imposed in addition to those imposed in the zoning regulation. And KRS 100-237, conditional use permits. The board shall have the power to hear and decide applications for conditional use permits to allow the proper integration into the community of uses, which are specifically named in the zoning regulations, which may be suitable only in specific locations in the zone, only if certain conditions are met. The board may approve, modify, or deny any application for a conditional use permit. The board shall have the power to revoke conditional use permits for non-compliance with conditions of approval. Granting of a conditional use permit does not exempt the applicant from complying with all requirements of building, housing, or other regulations such as zoning standards. So board considerations for this application: if the site meets the locational standards for such facility, if the site can reasonably meet the minimum standards specific to this use, if the site will generate significant off-site impacts or nuisances, and if any potential off-site impacts can be minimized or eliminated with specific conditions of approval. So the conditional use in question is the temporary outdoor storage of vehicles, which is an outdoor storage facility as defined by our ordinance. And section 453C of the ordinance, where outdoor storage is listed, lists it as a conditional use in the I-1 zone, provided that 4 site conditions are met. So the first, storage must be incidental and accessory to the principal use of the property. Staff finds that the storage of vehicles is incidental and accessory to the primary practice of operating a towing business off of the site. And the use is also incidental to the principal use of the site in the sense that this is being leased from the primary owner. The second requirement, the storage shall not be visible from any right-of-way or adjacent area of different zoning classification, and the Board of Adjustment may impose any reasonable conditions calculated to provide the required screening. So the applicant has indicated, and as you can see here, that they will stage the use to the rear of the property and it won't be visible from the right-of-way of Delaplane. And the existing tree lines and structures on the property will effectively shield the use in question from being visible upon those adjacent A1 parcels, which you can see on the zoning map here. Third requirement, the screening utilized to prevent visibility of the outdoor storage area may consist of earthen mounds, plantings, fencing, or walls. Existing tree lines provide screening in terms of visibility. Existing structures upon the site similarly prevent visibility from neighboring properties. The site will be required to have additional screening and buffers to limit disturbance to the neighboring A1 land, including a 6-foot-tall no-climb fence where it abuts all A1 properties. So staff does recommend, as a condition of approval, that this fence required by that article enclose the portion of the property that the applicant will be leasing from the owner, but that can be discussed later with conditions of approval. The use will also require a 50-foot property perimeter buffer adjacent to all common boundaries with A1 zone land. And upon site visit, staff does find that existing site conditions enable the use to meet this requirement. And the last requirement for this specific use, the storage area boundaries must satisfy the minimum setback requirements of the zone. Per the schedule of dimension area regulations, I-1 zoning district requires setbacks of 50 feet from the front and side yard and 25 feet from the rear yard. Article 6.14 requires 50-foot minimum setbacks for all structures and uses when adjoining A1 zone land. And because the site adjoins A1 property, essentially to all directions, it will require 50-foot setbacks from all adjacent property lines. So findings, the site is a 5-acre parcel zoned to I-1. The zoning district of the site is compatible in nature with the use in question. Approval of the conditional use permit would not adversely impact the public health, safety, or welfare and would not alter the character of the general vicinity. The no-climb fence would be more effective if it was placed around the specific area the applicant will be leasing for the use, as opposed to encircling the entire property, as the existing tree lines already provide effective land use buffering and visual screening. Setbacks of 50 feet from all property lines would satisfy the intent of the ordinance and protect adjoining agricultural land. The proposed use promotes the public health, safety, and welfare in the sense that towing is a necessary service for the community. Conditions limiting hours of operation and the intensity or volume of the use can further nullify potential disturbance to the surrounding area. And lastly, the conditional use in question is an outdoor storage facility incidental to the primary use of a towing business. The application meets the requirements outlined in section 4.53C of the ordinance for outdoor storage facilities. So given findings and analysis, staff does recommend approval of the application for a conditional use permit. And we recommend the following conditions of approval. The property is subject to all requirements of the Georgetown-Scott County zoning ordinance and the subdivision and development regulations. The applicant shall comply with all requirements of other federal, state, and local regulatory entities and shall provide copies to the Board of Adjustment of all permits issued on behalf of the applicant. As a result of this approval, including but not limited to business-related certifications, licenses, regulatory permits, and any recertification when required. The applicant shall return to the board prior to any changes in the approved conditions or new uses. The conditional use permit shall become null and void upon the transfer of ownership, sale, or the end of lease of the project site. Existing tree lines, particular to the east and west, must be preserved and maintained in such a manner that ensures an effective buffer. No external lighting of the outdoor area of use shall be permitted. The hours of operation shall be restricted from 8 a.m. to 8 p.m. on Mondays through Saturdays and from 12 p.m. to 8 p.m. on Sundays. No more than 20 cars may be stored on site at any time. Vehicles may not remain on site for more than 45 days at a time. And vehicles stored on the site shall be exclusively in storage. The applicant must not repair, dismantle, or otherwise alter any vehicles on the site because that would constitute a junkyard under our ordinance. The applicant shall return to the board prior to any changes in the approved conditions. The storage area must be a minimum of 50 feet removed from all property boundaries. The 6-foot no-climb boundary fence required by Article 6.14 must be erected around the portion of the site that the applicant will lease for the use, and the fence must enclose the entire portion of the site that the applicant intends to lease from the owner. And lastly, the portion of the site that the applicant intends to lease must be located outside of the floodplain. Our director had conversations with the applicant earlier today regarding staff recommendations. And would you like to speak to these?
Okay, so two specific things that we'd like the board's consideration on. The first relates to the number of vehicles that can be stored on site. In reviewing this application, we recycled a lot of the information that had been provided at a previous application to the Scott County Board of Adjustment. Inside that application, that was going to be at a residence, and so there was some consideration to the total number of vehicles that would be allowed on site. We took that information, we moved it forward. We had been in conversation with the applicant to basically confirm that was accurate. In talking to the applicant, they really feel that that limit of 20 may be too restrictive for their business. Staff, unfortunately, just has not spent the time to analyze what they're requesting, which is really approximately 35 vehicles at any one point. I think the applicant would agree that 100 vehicles is too much. It's just that 20 might not be enough. And so we'd just like to give it to the board for some consideration. I'm sure the applicant would be happy to talk about how many cars they realistically expect at any time. But, we just went through some major weather, and so the need for towing probably went up in this period of time. And so we don't want to be so restrictive as to not allow them to serve the community and be that benefit. But at the same time, just with the, with the site being what it is, we do realize that some reasonable restrictions should be placed. The second one is related to the storage of the vehicles not to exceed 45 days. The intent of that was to not have vehicles on site indefinitely. However, in discussing with the applicant, there's some state statutes that essentially after 45 days of holding a vehicle as, that's been towed to your site, after that, the towing business has a process by which they can claim ownership of the vehicle to basically cover the cost of that impounding or that holding of that vehicle for more than 45 days. And so what we'd like is for the board to consider modifying that requirement to essentially be that after 45 days of holding a vehicle, they need to initiate that process to basically take ownership of that vehicle and then do it with it whatever it is that they see fit, whether that's to sell it off or, and again, the applicant being the expert in this matter, I think could illuminate that. But those were two conditions that we feel like this board should in particular pay attention to and may be able to analyze potential impacts.
Do you have the aerial photo that shows what's on there now?
Yeah. So
Isn't
this
there
is
like
one
a-
of them.
yeah.
That shows the floodplain there. Again,
Yeah, but
staff
what's
wants to
the-
protect that.
Yeah,
And then
that,
there's-
that one. What's on there now?
That's a number of different uses. Yeah. Yes, please.
So staff did take a site visit out to the proposed site for this use. We found that it was, if you had to assign something that's defined in our ordinance, it would be a junkyard or an outdoor storage facility. It was mostly the storage of broken down vehicles.
Do you know if those will be remaining there?
The applicant may further speak to it, but
Okay.
yes, to my understanding, they will remain on the
I
site.
mean, because it looked like there's probably already 35 cars there now.
Can you put that flood picture back up? Flood
Floodplain.
zone?
Yeah, if you expand the number of vehicles, how much closer are you going to get to that floodplain?
So, as it pertains to this conditional use permit, we're trying to regulate in relation to this specific application. Holden, would you speak to the current?
Yes, I think Mr. Smith did a pretty good job basically saying that this is a industrial zone parcel. It's been previously developed. It has a long existing use on the property. We are trying to add in this particular component, and give credit to the applicant. They're trying to go through the proper process to basically bring this use online. And so the floodplain is what the floodplain is, and we've identified it on this map here. The applicant, in discussing this proposal with us, has obviously identified that area that you see in the top right side of the picture as where they plan to actually implement this new use. And so the existing use is likely to continue. This new use will come in. That's actually one of the reasons why I think that fence is going to be so important. That fence in delineating where this particular use is going to go on the property will also make sure that it doesn't bleed over accidentally into these the floodplain or the other environmentally sensitive areas on site. And now, obviously, we're looking at this picture here, and it shows cars parked in the floodplain as it is. That's a pre-existing use. We're trying not to get into that. I don't want to make this applicant basically responsible for anything beyond what they're specifically proposing, and that's what our conditions are focused on, is mitigating the impacts of this use in the area that they have identified.
Any other questions for staff? does the applicant wish to speak to add anything or potentially answer some questions? Yes.
I mean, if you have any questions, be glad to answer them.
The only question I have is, if you're retaining all of what's on there right now, isn't that gonna be pushing the 35 car limit already? Are you gonna be able to
Our
add?
lot is not with that. It would be pressed back and it would be separated from that and it would be fenced in all the way around. And the
Okay,
only thing
okay.
we'll be using is what's inside that fence. Nothing else. We will not go anywhere else except for there. We did ask to extend up to at least up to 35. That's the maximum we want anyway. That's just in case, like
Right.
we've had bad weather and different things. And you
Sure.
may get more cars coming in before you get cars going out. So that's the reason we requested that.
But this,
But it
so
will-
the section that you're gonna fence off is gonna be a clean slate?
Yes.
There's not gonna be anything there?
No.
Starting from zero?
No.
Got it. Okay, that helps.
Any other questions?
Any other questions for the applicant?
Can you go back to the picture where the floodplain was on the picture? I'm just,
Which picture?
The flood.
The floodplain, she said?
Floodplain.
what is the red writing? I think that's, is that where you were proposing?
Yeah. The red,
writing
Uh-huh.
is where we would be going.
Huh?
Where the red writing is,
Uh-huh.
there is where we would be going.
Okay, that's, I couldn't read the red writing, what it was saying, so that's the reason I was asking, what was it saying, okay?
What's currently there now, trees?
yes, sir.
He got most of them pushed out already.
He's already cleaned out an area for us, and it will be fenced off, and we will not bleed into anything that's beyond that point that's fenced off. We will stay exactly where we are. We do not dismantle cars. We don't do anything. We just have the insurance company comes picks them up, or the owners comes picks them up, and they, they go in and out, is all basically they do. And we tow cars in. The time periods, we're only open, in the summertime, we're open till 6, from 9 to 6. In the wintertime, we're only open 9 to 5. Now, him moving about, like, he would come in, he could come in at all hours of the night, but there's nobody there, and we wouldn't be bothering anyone or anything like that, because he would just be towing cars in, dropping the car and leaving.
Anybody else?
And you can go from 20 to up to 35 without infringing on the increased setback that was put into the conditions?
Right, I just said up to 35. We will not expand any more than what we can get in that lot. If we have too many cars in that lot and we can't take something into that lot, then we won't take the call.
You're not gonna stack cars on top of each
Yeah,
other?
we're not gonna take the call, we're not gonna, store any more cars than what we can get on the lot. If that makes sense. I'm just saying 20 cars is just too less.
Okay, thank you. Go ahead.
Just to confirm, upon, taking aerial measurements of that area where they have that planned use, they have about 150 square feet in there between that eastern property line and the floodplain. So as staff, we did find that they would be able to meet that 50-foot setback requirement.
How many square feet?
About 100,
Not square feet.
Okay.
yeah, I apologize. I misspoke there. Yeah.
Little teeny tiny cars.
Okay, yeah, that makes more sense. Okay, I got it. Any other questions? Does anybody else wish to speak on behalf or in opposition to this
Oh,
applicant?
wait a minute, I'm sorry, one more question.
Yeah, go ahead.
What is the normal amount of processing time, once you hit the 45 days? What's the normal amount of processing time for, in other words, we're looking at expanding beyond the 45, historically, what are you running into with a normal amount of processing time?
Well, the only time that we would keep a car more than 45 days is like if you get a car in and it is worth selling or taking possession of, then that's when that 45 days goes over. Okay, and when we do that, we have to put it in the newspaper and run it for 2 weeks, okay? And then we have, in that ad, we have to say that this car will be sold or took possession of on certain date, within that 2 weeks. So it'd be 2-week expansion is all.
Okay, 2 weeks, okay, thank you.
Anybody else that wishes to speak, either for or against? Okay. I'm okay with increasing the amount and the days as long as they initiate that claims process. So I'll make a motion to approve based on staff recommendations with the added measure of increasing it up to 35 vehicles. And that once the 45-day period has been met for a vehicle staying there, that they initiate the claims process immediately.
Right, second.
Let me know when you're ready, Charlie.
Okay, 1 second.
No problem. Take your time.
So not adding 2 weeks for that, since things can obviously always happen and maybe extended, just they need to start it immediately.
I think so, yes.
Okay.
The claims process to be started immediately after that 45 days of that specific vehicle. A lot of time there.
Here, I've got it. Okay,
I second.
yes, got that too.
Okay, all those in favor? Aye. Aye. Any opposed? Okay, motion passes as presented. Or motion is approved as presented. Thank you. Okay, B, application B, next on the docket.
So,
Thank you.
second on the agenda, another conditional use permit application. G 2026-05, conditional use permit for an assisted living facility. The location is McClellan Circle, Tract 5 of the Georgetown Commons site. It does not yet have an address. The zone is R3 high-density residential. Surrounding zones are R3, A1, A5, and B5. The lot size is 9.94 acres. Direct access is from the planned Gardner Boulevard. It's been previously platted, it does not exist yet. And arterial access is from McClellan Circle. And staff does recommend approval of this application. So you can see here, this is, you have McClellan Circle to the north there, and this is kind of the entirety of the Georgetown Commons site. In red at the bottom right is Tract 5 where this assisted living facility will go in. You can see here the zoning map for the kind of the surrounding area from this proposed project site for this use. So to start off, the comprehensive plan does indicate a need for uses of this nature. Housing for one, to increase the availability of assisted living facilities and shelters. Housing for two, increase the availability and the flexibility of housing options for elderly residents. So as indicated by the comp plan, the use of an assisted living facility, it would promote the public health, safety, or welfare in relation to KRS 111-6. So, site is located upon Tract 5 of the Georgetown Commons Development Site. The site was rezoned to R3 in October of 2024. Some of the potential impacts of this use on Tract 5 were considered, but the conditional use permit remains as a requirement per the ordinance. The application for the conditional use permit is running concurrently with the preliminary development plan to be considered by Planning Commission staff as a ministerial application. The scale of the use includes 146 dwelling units with a planned density of 14.7 dwelling units per acre. Building height is noted as 3 stories or 47 feet on the development plan. You can see the development plan here. And KRS 100 statute for conditional use Won't read all of this again, but board considerations. If the site meets the locational standards for such a facility, if the site can reasonably meet the minimum standards specific to this use, if the site will generate significant off-site impacts or nuisances, and if any potential off-site impacts can be minimized or eliminated with specific conditions of approval. So under section 4.35G of the ordinance, assisted living facilities are listed as a conditional use in the R3 zone, and they are subject to specific use regulations. And a board interpretation is being requested as part of this application regarding building height requirements. So we'll start with the building height analysis. The application indicates a planned building height of 3 stories or 47 feet. And under the ordinance, 3 stories are explicitly permitted as a by right use for assisted living facilities. What is not explicitly by right allowed is anything over 40 feet in height. So some analysis of the consideration of this. These facilities should be designed so as to cluster the residential units and associated buildings based on the net density and provide sufficient open space and amenities areas. So the 3-story or 47-foot building height does kind of meet the intent of this requirement. It clusters the building areas and preserves extra space upon the tract. The extra space created by this clustering allows for additional landscaping, increased setbacks, increased parking, and a pedestrian access easement to the south. The schedule of dimension area regulations does make the provision that the height of buildings may be increased up to 50 feet, provided that each side yard is increased, the side yard setback is increased by the same amount over the required minimum that the building height is increased over the otherwise required height maximum. So in this case, because the use in question is already held to an increased setback of 50 feet, where the property abuts all residential or agricultural zoning districts, and it abuts agricultural residential zoning districts on all sides. It has 50 feet increased setbacks, which gives it, per the schedule of area, dimension area regulations, it gives it allowable increase in maximum height to that 47. So in terms of access, circulation, and traffic, 254 states that development shall be located on an arterial street, collector street, or sub-collector street. The site will be served by Bring-Gardner Boulevard, which is a planned private collector street for the Georgetown Commons development. And the common site in its entirety will be accessed by McClellan Circle. Off-site grocery and other commercial and medical conveniences should be within the ability of aged persons to reach them easily by one of 2 ways: within safe walking distance, within 2,000 feet, or by owner-operated transportation service within a 5 to 10 minute ride to grocery, commercial, or medical sites. So you can see here, and noted on the development plan, you can see a pedestrian access easement to the top of the plan there. This is the concept plan at the time of zone change. You can see the commercial conveniences located on the common site that would be within 2,000 square feet walking distance of the site. And included here is a 1.5-mile radius of nearby medical conveniences to the site. You can see pharmacies, and you can see Georgetown Community Hospital, all within 1.5 miles of the site. So staff does find that the application meets locational standards as it pertains to the ability of residents to access those nearby amenities. The applicant has also indicated that the development will provide transit for residents of the site. The applicant may speak to the finer details of these transportation options provided to residents. So another requirement, the street network shall be capable of accommodating the traffic generated by the proposed use. Staff posits that the assisted living facility on Track 5 will not create significant traffic impacts with a total of, well, using ITE generation formulas, has a total of 26.28 peak AM trips and 35 peak PM trips. Traffic and road improvements have been conditioned with the previous commission projects for the overarching commons development. So parking, all assisted living facilities must provide a minimum of 3 parking spaces per every 5 residential units. So per that metric, the required amount of parking spaces for this site would be 88. And as indicated on the development plan, the site will have 148 parking spaces. The ordinance also requires a minimum of 10% of these spaces be handicap accessible, and the development plan indicates that 15 or slightly over 10% will be handicap accessible. Offsite impacts. The location, design, and operating characteristics of the use shall be compatible with and not adversely affect adjacent properties in the surrounding area. Staff finds that assisted living facilities are unlikely to negatively impact neighboring property owners. They do not generate light flashes, odors, continuous loud noises, vibrations, or other disturbances. Staff believes that the use is compatible with adjacent areas, while nearby development does not create precedents. Many nearby developments are high-density residential, including but not limited to Track 3 of the Georgetown Commons site, which was also rezoned to R3. The Amerson Townhomes and Apartments directly to the northeast are an existing high-density R3 residential development. And properties off of Aberdeen Way, located west of the project site, are also high-density residential development. 2.54, the proposed development shall be harmonious with the surrounding buildings with respect to scale, architectural design, and building placement. So the compatibility of R3 characteristic development was considered by legislative bodies at the time of the zone change to R3, and it was deemed to be appropriate. The aesthetic character of the site will be harmonious with the surrounding area, and the development does provide adequate open space and tree canopy coverage per our regulations. Building placement will be central to the site, and building lines will be 50 feet removed from all adjacent properties as required by the 50-foot setbacks. And the scale of the development is relatively small for the R3 district. The applicant may further speak to the aesthetic character of the proposed development, and our zoning code does not necessarily dictate the aesthetics. So screening, buffers, and setbacks. Screening, increased setbacks, and fencing requirements will be required for this use. The intent of these requirements are just to minimize any potential disturbance that it may pose to the surrounding areas. These measures include increased setbacks of 50 feet from all common boundaries with residential or agricultural zoned properties, and this will be upon all boundaries of the property because it abuts exclusively residential A1 or A5 properties. It will require a landscape buffer of 50 feet adjacent to all common boundaries where it abuts agriculturally zoned properties, and it will require a 6-foot minimum height fence of diamond mesh or equivalent no-climb wire where the property adjoins the A1 zone properties to the southwest. You can see included here increased setbacks. Increased setbacks to 50 feet from adjacent agricultural and residential properties. You can see it's kind of difficult to see. You can see the 6-foot tall fence indicated here, and you can also see a 4-foot fence here. It's not necessarily required by our ordinance, but it will be placed here where the property is adjacent to residential zone properties. So findings, the tract in question for this conditional use is a 9.94 acre tract zoned R3. Assisted living facilities are explicitly named as a conditional use in the R3 zone. The application meets the zoning-based minimum requirements of the Schedule of Dimension Area Regulations. The application will meet the specific use-based minimum requirements outlined in 254 of the ordinance. The 3-story building height is by right for the use, and the increased setbacks do provide for an allowable 47-foot building height in pursuance to the provisions of the schedule. The application and the development thereof may play a role in addressing the housing objectives of the comprehensive plan. The use of the site is contingent on the development plan, and that will be evaluated by the commission rather than the Board of Adjustment. The site will be accessed by an arterial street, collector street, or sub-collector street. The site must have walkability and readily available transit for tenants to access the nearby shops at Georgetown Commons. The proposed facility is unlikely to have off-site impacts upon the surrounding area, and the requirements of Section 2.54, as well as the landscape and land use buffer ordinance, are intended to further minimize any off-site impacts that the development may have on the surrounding agricultural or residential areas. The use promotes the public health, safety, and welfare pursuant to KRS 111-6 in the sense that the comprehensive plan does indicate the need for assisted living facilities. So staff does recommend approval of the conditional use permit for the 3-story, 47-foot high assisted living facility with 146 dwelling units on Tract 5 of the Georgetown Commons project site, and staff recommends the following conditions of approval. We have our standard conditions of approval for conditional use permits. No certificate of occupancy shall be issued prior to certification of compliance with the voluntary certification of assisted living residencies standards, and that's state statute. No certificate of occupancy shall be issued prior to the issuance of required permits and certificates by federal, state, and local agencies, and all required conditions of approval by the Board of Adjustments and the Planning Commission. All conditions that may be imposed regarding the development plan for the site, and failure to comply with those conditions will also nullify the conditional use permit for this use. If the conditional use permit cannot be exercised within 1 year, public hearing and re-review of the permit must be held. Development shall be located on an arterial street, collector street, or sub-collector street to be kind of further considered in relation to the development plan. Each of the 146 dwelling units shall contain at least 400 square feet of gross floor area. The buildings to which the permit pertains must be set back a minimum of 50 feet from all property lines. All applicable requirements of the landscape and land use buffer ordinance. And this last one was added after the packet went out at the request of the applicant. Upon creation of an LLC by the applicant, Denton Floyd, for the management of the Georgetown Commons Assisted Living Facility, the applicant shall submit to Planning Commission staff documentation establishing ownership of the subject property. The applicant and Holden may further speak to that last requirement that was added after the staff report went out. Does the board have any questions for staff?
Thank you. Does the applicant wish to add anything further to that?
Good evening. Scott Schutte on behalf of the applicant. We passed out a packet that gives you a little bit of an overlay of the property as a whole and then this specific tract that we're here about tonight. Just a couple of comments. You can see kind of the way this property interacts with the remainder of the commons and how it's walkable, and there's going to be amenities there for the residents of this facility. Like staff said, there's ample medical uses within the mile-and-a-half radius that makes this an attractive spot for a senior living facility. Also included in your packet is a market study that identifies a need for 125 beds as of 2025 for assisted living facilities, and by 2027, that number can get up to 140. This use, we think, will help that shortage. As far as condition 14, I think we should be fine on that. Obviously, in these large-scale developments, the applicant or the developer may not ultimately be that end user. This use will remain the same, but the name, just the name of the entity that is operating it may change. So 14 should take care of that need as long as it's not going to be conflicted with condition 4. As long as we're on the same page, we're good.
Yeah, to clarify, this is something that the applicant brought forward well in advance. Ownership at time of development might not be the same as ownership at time of execution of this plan. And so as long as we have that LLC remain consistent during the operation, that's what staff is primarily concerned with. And so, yes, at time of creation, we just note that and then we move forward.
Okay.
And this will be phased in when? When will that first phase? The three-story building, when will that happen?
When will this specific track be developed? I don't know that we have a date certain for that. We still have to go through the development plan process at the Planning Commission for the entirety of the project, and then development will begin.
And you said it.
So what you all are looking at the use, just the use as an assisted living facility tonight. The zoning in the development plan will be in front of the Planning Commission and staff.
Any other questions? Does anybody else wish to speak on behalf of the applicant or opposed? Are you guys good?
One more thing to add as staff is the motion to approve this conditional use permit would entail the approval of the board interpretation of the height requirement. As of now, this application is a ministerial application, or not the conditional use permit, the development plan for the site is a ministerial application to be considered by staff, so it will not go before the commission. We found as staff that the board, in relation to this conditional use permit, can grant the 47-foot height based on this analysis included here. But that is ultimately to the board's discretion, and I can answer any questions that you may have about that.
And so basically the way that comes about is under the R3, we are not as dense, meaning we could put more rooms on this track than we're currently showing. So in decreasing that density comes up about 7 feet.
And we as staff do find that it is allowable just based on the schedule of dimension area regulations, which does allow for that increase in building height up to 50 feet, based on increased setbacks. Because these buildings will have increased setbacks of 50 feet from all property boundaries, we find that it is it's acceptable based on the requirements of the ordinance.
Okay. Anything else, or does anybody want to make a motion?
I make a motion to approve per staff recommendation.
Thank you, Jeremy. Any second?
Second.
Clem? Clem for the second. All those in favor? Aye. Any opposed? Okay. Motion is accepted as presented. Thank you all.
Thank you. Thank you.
C, yep, application C.
All right, last one of the night. Have a variance application at 101 Meadow Lane. It is a variance to allow for the expansion of an existing non-conforming use. The zone is B4. Surrounding zones are B4, R1C, and A1. The lot size is 0.54 acres. Direct access is from Meadow Lane. Arterial access is from Champion Way. And staff does recommend denial on this application. So you can see here an aerial view of the site in question. You can see on the zoning map here. So the parcel at 101 Meadow Lane has an existing non-conforming sign displayed towards the street frontage on Champion Way. And the sign is non-conforming because it is a freestanding pylon-type sign, which is not permitted in the B4 zoning district. There is no record of approval for a variance for this existing non-conforming sign, and the applicant has requested approval of a variance to replace this existing sign with one of the same basic type and similar dimensions, although the new sign will be completely digital display. This is material submitted by the applicant showing where the existing sign is on Champion Way there. And this is a photo taken by staff upon site visit of the existing freestanding pylon sign on the site. And this is material submitted by the applicant. This is the freestanding pylon sign that they are planning to replace the existing one with. KRS 100-243, findings necessary for granting variances. Before any variance is granted, the board must find that the granting of the variance will not adversely affect the public health, safety, or welfare, will not alter the essential character of the general vicinity, will not cause a hazard or nuisance to the public, and will not allow an unreasonable circumvention of the requirements of zoning regulations. The board must consider whether the requested variance arises from special circumstances which do not generally apply to land in the general vicinity or in the same zone. The strict application of the provisions of the regulation would deprive the applicant of the reasonable use of the land or would create an unnecessary hardship on the applicant, and the circumstances are the result of the actions of the applicant taken subsequent to the adoption of the zoning regulation from which relief is sought. So board considerations. The application ends up kind of by default requesting relief from a lot of different articles of zoning regulations. First, it requests relief from Article 6C7 of the sign ordinance, which does not allow for freestanding pylon signs in the B4. Secondly, it requests relief from Section 1D1 of the sign ordinance, which basically just says that non-conforming signs are held to the same standards as non-conforming uses and structures. So it also entails relief from 241 and 242 of the ordinance, which is non-conforming structures and uses as an expansion of a non-conforming use or structure. And lastly, the planned digital display face, as seen here, exceeds the maximum amount of changeable copy area that a freestanding sign may have under Section 6C5 of the ordinance, and that is 30%. So the entire sign face in this case is digital changeable copy display. So analysis in relation to KRS. The variance will not adversely affect the public health, safety, or welfare, will not alter the essential character of the general vicinity, will not cause a hazard or nuisance to the public. The reestablishment and expansion of the sign would pose a threat to safety, as a digital sign has greater potential to distract drivers upon Champion Way. And staff does find that because Champion Way is a state road, it is crucial to reduce potential hazards to driver safety that would result from the light emitted by such a digital sign. It must not allow an unreasonable circumvention of the requirements of zoning regulations. And staff does find that the granting of this variance would create an unreasonable circumvention. And that's really just on the basis of the scope of articles from which relief would be granted, because it would allow for not only a pylon sign in the B4, it would also allow for the expansion, the reestablishment of an existing non-conforming use. So the strict applications of the provision of the regulation would deprive the applicant of the reasonable use of the land or would create unnecessary hardship. The applicant argues that denial of the variance would create hardship, as signage and advertising would not be visible to drivers on Champion. And staff does find that this circumstance does not create hardship under KRS for the following reasons. The existing sign is easily visible in surrounding areas without the added digital display, and staff kind of confirmed this on a site visit. The site possesses reasonable alternatives to the variance, and the applicant is in their rights to display a monument sign that may add digital display, and it may front Meadow Lane. The existing non-conforming pylon sign already serves the purpose of visibility to drivers on Champion, and it does not create further unreasonable circumvention of standards or potential hazard to drivers. The grading slope to the north, the frontage upon Champion Way, while it is unique, it is not steep enough to create hardship or deprive the applicant of the reasonable use of the land. And you can see here, there is about 10 feet of difference, as seen by the contours here, between where the sign would be displayed and the elevation of Champion Way. And it is flat over towards the east, or Meadow Lane. So findings. The site in question is a .56 acre parcel, zone B4. Under section 6C7 of the sign ordinance, all freestanding signs in the B4 must be ground monument signs. Any approval of this application would grant relief from 6C7 for the display of a pylon in the B4, 1D1, which just states that non-conforming signs are subject to 241 and 242. Section 241 and 242 of the zoning ordinance, which states basically that non-conforming uses and structures cannot be reestablished or expanded. And then it would also grant relief from section 6C5 of the sign ordinance in exceeding the maximum 30% of changeable copy display face. The expansion of the existing non-conforming sign may create a threat to the public health, safety, or welfare, or a nuisance or hazard, as the large digital sign is likely to distract drivers upon Champion Way. Granting of the variance will allow an unreasonable circumvention of the zoning regulations, as it requests relief from the 4 articles that we discussed. While the grading slope to the north of the parcel is a unique circumstance, it is not intense enough to deprive the applicant of the reasonable use of the land or to create hardship. Reasonable by right alternatives to this proposed sign do exist, including a monument sign that would have digital display as an option. And while staff does find that the reestablishment or the expansion of this existing non-conforming sign does not meet the requirements, it does not necessarily necessitate the removal of the existing non-conforming sign under section 241 or 242 of the ordinance. The expansion of the existing non-conforming sign, oh, I apologize, that's a typo. So staff does recommend denial of the variance for the expansion of an existing non-conforming sign on the property. And should the board approve the application, staff recommends the following conditions of approval. Our standard conditions of approval for variances. All requirements of section 3F 1 through 4 of the Georgetown sign ordinance for changeable copy and electronic signs. The sign must be set back a minimum of 10 feet from all property lines. The sign must not exceed 20 feet in height. The total display face of the sign must not exceed 75 square feet per each side. And the digital changeable copy area of the sign must not exceed 30% of the total sign face. Does the board have any questions for staff?
Could you go back to the first image you had up there?
Yes, sir. This image?
Right there.
Any questions for staff? Does the applicant wish to speak? Go right ahead.
I'm Jill Bruner. I'm the in-house attorney for Spectrum, and so I am here. We really just applied for this variance as like a proactive measure. We don't really even have a final version of a digital sign. We absolutely would comply with the conditions of the approval. and would ask that the board consider at least conditional approval upon, bringing back to the board final version, when we have a final version of a digital sign. And we would conform with, all the requirements, the conditions, the minimum setback, the not exceeding 20 feet, not exceeding 75 square feet per side, and then also the digital changeable copy will not exceed 30%. We would all show that in any future application. We do appreciate and understand the concern for, public safety in this circumstance. But, we would definitely avoid any elements like flashing, blinking, scrolling, or any like rapid changes that would potentially distract drivers. We understand that could be a distraction, and so we would stay away from any of that. There are other, obviously digital signs around town on Champion Way at major intersections. They're not necessarily, just because they're digital, linked to, any collisions or public safety concerns or anything like that. We would absolutely work with the board on making sure it is, safe for the public. So, yeah, I would just ask that, at least approval based on these conditions of approval that staff has recommended, or at least conditional approval to come and bring back a final version of a sign, yeah.
Any questions for the applicant? Okay, thank you.
Thank you.
So for staff, the existing pylon is non-conforming from a previous owner, correct?
Yes. I believe a bank owned it 3 to 4 years ago, and that sign was there when they purchased the property. We cannot find any record of any kind of approval for the non-conforming sign that currently exists. So it does have that non-conforming status.
And your requirements for that sign, was it told to them prior to them bringing this before us?
Yes, sir. So this initially began as I believe it was a call to our office back in November. As staff, we spoke with the applicant, presented them their options and the requirements of the sign ordinance in relation to their plan. At the time that this application was submitted, our understanding was that it would be an addition to the existing sign and not necessarily taking down the existing sign to put up a completely new one. But we did present them the option, the fact that they had an option to apply for the variance, and we did not speak to the likelihood of approval or denial for the variance. We tried to present the by right alternatives and then the statute for variances that they would be held against.
Can I speak to that just 1 second?
Sure.
So the existing sign, yes, was already there. The pole, my understanding from the sign company is the only reason we would have to replace the pole is because it couldn't hold a digital sign the way it is. That's the only reason we would have to replace the pole. Otherwise, it would just stay as is, and you'd replace the face and comply with the, all the ordinance requirements. So we're not looking to really change anything, just we want to convert to a digital sign, one, to increase visibility to clients. I mean, that's, basically what all these digital signs are for, right? I mean, all around town, there's many, and it's just higher visibility with a digital sign. We're not looking to be distracting or anything like that. But that's the reason why we'd have to replace the sign, the whole sign, because the digital sign would not hold under that existing pole.
If I may.
Yes, sir, yeah, go right ahead.
Difficult position that you
Yeah,
guys are in for this, and totally understand that. I do want to clarify that the staff's recommendation is denial. If you guys want to move forward, we've prepared those conditions, but the recommendation is denial. And specifically, when we look at something like this, which is a non-conforming sign, which is equivalent to a non-conforming use, or structure in this case, the intent of section 2.41 in our zoning ordinance is that at the end of the life of the non-conforming structure, it should go away. That is the expectation. And so in this particular instance, specifically when it comes to alterations of non-conforming structures, the language is a non-conforming structure shall not be enlarged, replaced, or altered except in conformance with the zoning ordinance. So in this situation, if we're looking to take it down, we need to be replacing with something that meets our zoning ordinance. Past that, you know, if the applicant was just looking to do a safety, you know, something to keep that sign safe and keep it standing, that's a different condition. But as soon as we talk about the replacement of it, we really want to replace it with something that meets the ordinance as it's written today. And then I'll leave you guys to figure this one out.
Right, but if it stayed the way it is, the applicant's protected under that, right? Wasn't there something on there?
Yeah, so the applicant, again, can maintain the existing sign. It's when
Right.
those modifications come in this case, the replacement of that's where that non-conforming, we want that structure to conform moving forward. Otherwise, non-conformities exist in perpetuity.
Right. Yeah, that stinks. I don't know. I feel like our hands are kind of tied with the ordinances that are on there. You know, it stinks that it's already non-conforming, but I don't know what else we can do. So,
And upon voting on this, will we allow them the chance to propose a different sign?
yes, because I think they have a recommendation for that, or not a recommendation, but
Proposal?
an option that can be suggested with the monument sign.
Yes,
I forget what
so
number it was.
it really is just a question of what the applicant wants, and we cannot necessarily,
Right, you can't
Right,
tell them exactly
yeah.
what they,
Right.
as a by right use or structure in the B4, ground monument signs are by right for that zoning district. Ground monument signs also can have that changeable digital copy on them by right.
yeah, what number was that?
I don't believe that's a condition of approval.
No, it was under I think a finding.
Yep.
I can't remember which one it was.
7.
Finding 7.
Now, I believe
Yeah.
the complication under that would be that
Frank, they had an alternative there on number 7.
each parcel is, I believe, allowed one freestanding sign per parcel under our ordinance. So if they did put up that by right digital display monument sign, it would necessitate the removal of the existing non-conforming sign.
Right.
And if they were to choose to do that, it wouldn't come before the Board of Adjustment, but we may speak with them as staff about it. But that's really up to the applicant.
Okay. Yeah, thank you. Sure.
So we did, look at the proposed alternative, and the way the property is slanted, Meadow Lane's like this, Champion's like this, and it's raised, and there's trees in front of our business, which are bare now, but, in the summertime, those trees will be full. You won't be able to see a monument sign from Champion Way or Meadow Lane. I mean, even right now, if we put one on Meadow Lane, you wouldn't be able to see it from the road because of the slope.
Okay.
Yeah, so that, just, you know,
That's- yeah,
giving you a
that's why
little,
you're doing that, okay.
yeah, background on how that, you know, why that probably wouldn't work, but, you know, we just want the chance to, you know, to come back, and when we do have, we were just trying to be proactive here and just have the chance to come back and propose a sign that would conform to these conditions of approval, you know. Obviously,
Yeah.
we don't want to do anything that, you know, jeopardizes the public safety or anything like that, but,
Sure.
you know, that's kind of what we were wanting to do.
Okay, thank you. Anybody want to make a motion? Yeah, I just feel like our hands are tied on this one, and I hope that something can be done to get the applicant where they need to be on it, but as far as this application, I'll make a motion that we deny based on staff recommendations.
I second.
Frank, thank you. All those in favor? Aye. Any opposed? Okay, motion denied as presented by staff recommendations is passed. Okay. Any other applications or anything from staff?
We have one administrative matter.
Sure.
So usually in March, we do our elections, so just something to be aware of as we
Thank you.
approach that.
Yes, thank you so much.
I believe, Nate, you are eligible to still run, Jeremy's eligible to still run. If anyone is feeling that calling to be chair, vice chair to the board, you're more than welcome to throw your hat into the ring at the March meeting.
Okay, and that's just something we present at the beginning or end of that meeting?
You would put it under other business, but
Okay.
if the board felt so inclined to do it as the first item of business and amend the layout of the agenda, you're more than welcome to do so.
No, we can do other business at the end. I think that's fine.
But, yeah. So if anyone's feeling that call, want to
Yeah.
hold the gavel.
So just be thinking about that for the next meeting, guys. Okay, anything else?
Not at this time, no.
All right. We are adjourned. Thank you all.